Sa Hule Kita Kilame Hirwatawata Tamarumo Tamarumo.
Afriforum has challenged Julius Malema in court because he led the singing of Dubula Ibunu at political rallies. The song's lyrics call for shooting Boer farmers, and Afriforum argues that this chant amounts to hate speech and incitement to violence against a racial group. In 2011, Afriforum took the matter to the Equality Court and won a ruling that the song violated the Promotion of Equality and Prevention of Unfair Discrimination Act. The ANC League, under Malema's leadership, agreed to withdraw their appeal and to refrain from using the chant. What responsibility do political leaders bear when their words can inflame violence and division? The dispute lay dormant until 2020, when a surge in farm attacks and the tragic death of a young farmer in Senegal reignited public fear and anger. Afriforum reopened its case in the Equality Court and argued that the chant could not be excused by history or protest context. In August 2022, the court rejected Afriforum's claim, finding that the psalm's origins in the anti-apartheid struggle gave it a political meaning protected by the constitutional guarantee of free expression. The judges noted that there was no evidence showing a direct link between the chant and actual murders of farmers. Should a protest song be judged by its historical role or by its potential to harm people today? Afriforum then appealed to the Supreme Court of Appeal. The higher court agreed that the chant carried symbolic weight, but emphasized that banning it risked setting a precedent that could chill legitimate political speech. The judges questioned whether a metaphorical call to resistance could ever be disentangled from a literal threat when the imagery is so vivid. How should courts distinguish between metaphorical and literal language in political discourse? In early 2025, Afriforum sought leave to appeal to the Constitutional Court. The Apex Court refused to hear the case and ordered Afriforum to pay the EFF's legal costs. The dismissal reaffirmed the strong protection South Africa's constitution grants to political expression even when the language is inflammatory. It also underscored that historical context can outweigh potential offense when no imminent threat is demonstrated. Does this ruling protect democratic debate, or does it allow hateful rhetoric to flourish under the guise of protest? At the midpoint of this legal saga, the public reaction split along familiar lines. Supporters of Malema see the courts as upholding the right to remember the struggle against oppression and to use powerful symbols of resistance. Opponents see the song as a relic of racial hatred that continues to traumatize a community that fears for its safety. Which side do you find more persuasive when you consider the balance between historical memory and contemporary harm? This case has profound implications for South African democracy. It forces the nation to confront whether the legacy of apartheid justifies language that, in any other context, would be condemned as incitement. It also asks whether the rule of law can both protect minority rights and safeguard the freedom of political speech. How would you draw the line between protecting a group from hate speech and preserving robust debate? The political fallout has been intense. The EFF has used each court victory to energize its base by framing the rulings as validation of Black political expression. Afriforum has portrayed itself as the defender of minority rights and the rule of law. Both organizations have leveraged the courts to mobilize supporters and to shape public narratives. What does this tell you about the use of legal processes as instruments of political strategy? Beyond the courtroom, the debate has prompted national reflection on the nature of hate speech laws. Should intention or impact carry more weight when evaluating inflammatory language? If a song was born in a struggle against oppression, does that history excuse it from modern standards of civility? What standard would you propose to judge speech that straddles the line between protest and provocation? Legal experts warn that a blanket ban on historical protest songs could undermine freedom of expression and open the door to censorship of legitimate political art. Civil society groups caution that allowing violent language in political rallies normalizes aggression and puts vulnerable communities at risk. Which risk do you believe is greater? The risk of silencing dissent or the risk of enabling violence? As South Africa continues to grapple with high levels of violence and deep social divisions, the Afriforum versus Malema case serves as a flashpoint. It illustrates how words rooted in a painful past can carry forward wounds into the present. It also highlights the challenge of crafting laws that honor history while protecting citizens from real threats. What lessons do you think other democracies might draw from this conflict between memory and safety? This report has laid out the facts of the legal battle, the court decisions, and the wider social and political consequences. It has asked questions about leadership, history, law, and democracy. What do you think about this? How would you resolve the tension between remembering past injustices and preventing modern harm? What reforms to hate speech legislation would you support to strike the right balance between free expression and public safety? If you found this analysis helpful and want to explore more in-depth reports on legal and political challenges around the world, consider subscribing to our newsletter. What issues should we examine next?